Turn to the fourth case on this morning's docket. Case number 115401, Terrell Breedlove, the state of Kansas.
May I have 3 minutes for rebuttal, Your Honor?
3 minutes is granted.
May it please the court, Kristen Patty appearing for the appellant Terrell Breedlove. This is a 1507 case. Mr. Breedlove was charged originally with crimes that he committed in 1995 when he was technically under the age of 18. And he was tried and convicted as an adult. And then in 2008, this court said, wait a minute. The district court didn't begin proceedings against him as a juvenile. You have to set that conviction aside, resume the proceedings as a juvenile, and then retry him. And that's what happened. They filed a juvenile complaint against him, even though by then he was 30 years old. And he had a second jury trial and was tried and convicted. And the mandate issued on October 9th, 2012. So about a month before the mandate, a month before the year anniversary of the mandate from his direct appeal, he files a 1507. And it basically sits for 2 years. He files a couple of additional pleadings in that time period. There's no indication really that the district court looked at it at all for quite a while. Eventually in July 2015, when we're getting close to the 2-year anniversary of his filing date, he files what he calls a motion for summary disposition. He invokes a rule of appellate procedure that, of course, you can't use in district court. And it gets sent back. And he's told that, the clerk writes him and says, the administrative judge, Judge Fleetwood, says, you can't file this unless you pay a $195 filing fee. So obviously, by that point, he thinks, there's no way I'm going to get a ruling on my 1507 if I don't give them $195, and he does. In the meantime, the Judge Fleetwood's office finally asks the district attorney's office to file a response to Mr. Breedlove's motions. And then in September 2015, the district attorney's office does. It's 39 pages long. 39 pages. 2 business days later, Judge Fleetwood puts on one of those infamous Sedgwick County motion minutes orders, or motion minutes sheets, on the cover and says, well, after extensive briefing, I'm just going to adopt all the findings of fact and conclusions of law that the district attorney gave me. There's no appointment of counsel for Mr. Breedlove. There's no, as we would use like in a Sixth Amendment context, which this isn't, but to borrow a phrase, there's no crucible of adversarial testing. I think there's a reasonable question in this case about whether Judge Fleetwood really could have given the state's response and the record, since he was not the trial judge, the appropriate consideration in just 2 business days. Did fall over a weekend. And of course, because Mr. Breedlove's motion was denied, he has appealed. The first argument made on appeal is that what the district court did when it basically delegated that role of resolving this dispute to the district attorney's office violated the Kansas Constitution. Article 3 places the power, the judicial power in this court and all the lower courts. We have a unified court system. And it's then the district court that has the original jurisdiction of all controversies that arise in that court, in that county, or in that judicial district. I found one case where there has been a delegation of the ability of a district court to get administratively through I can't remember what I call it, so I don't do domestic. But basically we can get child support disputes resolved through an alternative procedure. But there's no similar statute that permits a district court to delegate responsibility over a 1507 case.
How do we get to the delegation? Judge Fleetwood said, after reviewing the petition on this and the extensive response and briefing in this matter, the court finds the state's position compelling and adopts the state's findings of facts. Conclusions of law, the petition is therefore denied in whole. So the court made a ruling, adopted one of the parties' arguments, as happens all the time.
Suggested findings.
Suggested, yeah.
Well, but a lot of times when there's of course maybe both their attorneys.
There are a lot of problems with this, adopting that without with an unrepresented person. But that's not your argument. The argument is you can't adopt one party's suggested findings without being in violation of the Kansas Constitution. Or am I misunderstanding your argument?
Well, I didn't mean, if that's the way my argument is construed, I didn't really mean that. I think, as I used the borrowed phrase earlier, the crucible of adversarial testing, if I have seen other 1507s, for example, after an administrative or an evidentiary hearing, where both sides submitted proposed findings of fact and conclusions of law, and the judge adopted one side's. I think in that case I did argue that the constitutionality of it, and you denied my petition for review. But there at least was counsel appointed for the 1507 movement in this case, and there wasn't in this one. And in some ways it kind of is how it interlocks with, I like to use Lujan, partly because I know a lot of times you're using Sola Morales because it's a more recent case that basically says the same thing. But obviously Lujan is a lot shorter and a lot fewer characters when you're writing a brief and have a page limit. In Lujan, you gave us 3 options. You said the district court has 3 options. Certainly if the judge can look at the motion and say, this absolutely has no merit to it, then there doesn't have to be anything further. But if the judge thinks that there is possibly merit to it, and he asks the district, I think with a strict reading of Lujan, and I guess it would be 224506B, and he asks the district attorney for a response if there are potentially substantial issues of fact or law, then he also has to appoint counsel for the movement in this case, and that wasn't done. So I don't know, Justice Johnson, if that really completely answers your question. I think it is in some ways, at least in this case, how those issues are intermeshed.
It seems to me those are 2 separate arguments. Whether the court followed the correct procedure and whether the court was required to appoint counsel.
Right.
I see that argument. I'm having trouble grasping the constitutional delegation of authority argument you're making by the simple act of saying, I like one party's arguments, I'm going to take that as my ruling. Now, whether this judge had time in 2 business days to review 1,380 pages of record may be up for debate, but we can't make those kind of real factual findings, can we?
No, we can't. And, and I suppose both good and bad. We all do it with computers these days. You can cut and paste from one document to another and make it look like you did you made your own journal entry.
So let's talk about the argument that I hear you making about following the correct procedure.
Right.
That the court can determine from the motion files and records that the movant's conclusively not entitled to relief and summarily deny.
Right.
Okay. And so your argument here is that the court did not do that because the court considered the state's response. And at that point, if the court is going to consider the state's response, then an attorney needs to be appointed. Is that your point?
That is basically my point. I think with at least a strict reading of that, of Lujan in 4506B, the judge can look at it on its face and says, this has no merit, and summarily denies it. But yes, I think that once the judge decides, I need a response from the state, then I think there also needs to be the input of an attorney for the movement. I've argued before you in Monday about what kinds of things that an attorney appointed for a movement could do. And I think that if, particularly with Mr. Breedlove's motion, if an attorney had been appointed for him, it might have helped narrow and clarify the issues, might have framed them into a more constitutional violation context. And you and I and Mr. Gillette and the Court of Appeals before us would have been able to at least get a better grasp of what Mr. Breedlove's issues were and what are really the most important things that might have given him. We could be arguing about whether he should be getting a retrial. We wouldn't be arguing about procedure. I also think, and I realize I usually turn off you and the Court of Appeals when I say this, but this was his first 1507 motion. I'm not making this argument for somebody who's filed their 6th. It's his first. And I wish that there were a little bit more deference given to a first 1507 movement. Let's make sure that we get it right. So then we've kind of gotten to the second point, is that probably I believe that counsel should have been appointed for Mr. Breedlove. I think my brief goes into fairly well the trying to at least preserve Mr. Breedlove's allegations as far as ineffective assistance of his trial counsel. The other, and I can see that I'm running out of time and I'm having trouble getting to, is the problem of him being required to pay $195 to finally get a ruling on this case. I don't believe that that was permitted by law, and we would ask that the district court be ordered to refund that. And I'll save anything else for rebuttal.
Do we have any more questions? Thank you, counsel.
May it please the court, counsel. Good morning again. Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I will focus, I guess, most of my time on the one issue that was, or I guess 2 issues that were really discussed this morning, and that is, I guess, what happened with this case and this allegation of ceding authority. I don't think that the record actually reflects that there was any authority ceded here. The state does not have a monopoly on the correct answer in these types of scenarios. This is not any different than an objection at trial. If a defense attorney objects to hearsay testimony, the district court turns to the state and asks for a response, and we can provide that. This is no different.
So which, going through the 38 pages, which basis did Judge Fleetwood accept? I mean, it looks like Mr. Loudon's arguing that the motion records and file conclusively show that not entitled to relief, that the movant made conclusory issues, which is another area of the law, that there's no legal basis for relief, even assuming the truth of the factual obligation, then argued res judicata, then laid out the two-part test for ineffective assistance of counsel, then said, you know, you can go right to the prejudice without having to establish counsel's performance was deficient, and the court can take judicial notice of the district court files and the history of the case, even though it wasn't a trial counsel. And I'm just wondering, what did Judge Fleetwood adopt all of those?
Judge Fleetwood's order is, quote, after reviewing the petition.
I know what the order says. I've got it right here in front of me.
Right.
But from that, do we then have to go through here each thing that's alleged in Mr. Loudon's response and see if the Judge Fleetwood erred in adopting that? Because there's some in there that I don't agree with. I don't understand why under Moncla that's sufficient for our review. So how would you address that?
I think it's sufficient for your review because I believe that Mr. Loudon's response actually did address every single claim that the defendant made, and that's what's required. Is that there has to be enough of a record here that this court can review the district court's decision and say, you know what, on one ground or another, these are all correct.
Even if there's some factual allegations that may be suspect, we don't do factual determinations.
No, you don't. But I guess I would struggle to come up with a specific factual allegation that the state made that would have been in any way inconsistent.
Well, let's try this one. The sixth claim was that Mr. Sullivan was ineffective for failing to object and preserve issues for appeal. And on our first opinion on the direct appeal, we had several instances of issues that were not preserved because there wasn't an objection.
Okay.
Okay. So that's established, and then the answer to that is that there's no basis to conclude that Mr. Sullivan provided deficient representation by failing to object, or that his failure to object prejudiced the outcome of the trial or his appeal.
And I think that's enough. What does the defendant's statement there even mean? It's not specific. He just makes a vague, he failed to object. The defendant is held to the same standard as an attorney when he's proceeding on this, and there's nothing wrong with Mr. Loudon's response there. That is an absolutely accurate response to a vague and meritless claim. And I think that the meritless nature of that is bolstered by the fact that the district court did go through, as did the Court of Appeals, and address each individual claim against Mr. Sullivan.
But what the only way that you can that this could happen the way it happened is if the motion, files, and records conclusively showed that Mr. Breedlove was not entitled to relief. And the record shows that there's an opinion filed that Mr. Sullivan did not preserve, I think, 3 or 4 issues for appeal. He did not do that.
Okay, but the defendant didn't complain about those. As my best response to you, the defendant didn't identify those as issues that he wanted to raise as part of his 1507.
Yes, he did. He said he failed to object, and in fact, Mr. Loudon acknowledges that those are there. In fact, he lays out the parts on pages 26, 27, 28, 29. He lays out our parts of the opinion that identifies. So apparently he knew what Mr. Breedlove was complaining about, because he put it in his response.
I think you're trying to infer something that's really not there. I think the state probably made it what I would say is its best guess at a vague and meritless allegation and addressed those as best as it could. And again, the burden is on the defendant to come forth with a claim that shows that counsel was both objectively unreasonable in their representation and that somehow he was prejudiced. And he doesn't do that as to any of his claims. And so I think the second thing that I can say that was tied into the argument today is the right to counsel. And I think the Court of Appeals got this issue exactly correct by doing what they did, which is follow along and address each and every claim that was made, find that they were meritless for one reason or another, and because of that, the motions, files, and records of this case do indicate that summary dismissal or summary rejection of the defendant's motion was appropriate without the appointment of counsel. I think that
And it's okay to do that with input from the state and no input from a lawyer representing the movement.
Yes, I think that it is. There's nothing.
You think that it is. What would you cite to support that? That's a little gap, I think, in the three options under Lujan.
I don't know that it's a gap, because again, a defendant that's pursuing this type of a motion pro se is acting as his own counsel. There's nothing in the statutes or in the case law that says the state is, and I put this is in my brief, this is my original brief to this court, or to the Court of Appeals that is now before this court. There's nothing in statute or case law that A, requires a response.
I understand we
Or
don't
says
have
we
it
can't.
yet. So what's your, other than I think so, what's your best argument?
The best argument that the state can make a response?
Yeah, to that idea that once the state is permitted to have a lawyer weigh in, the defendant ought to be permitted to have a lawyer weigh in.
My best response
That strikes me as your opponent's strongest argument today.
My best response is the state's always able to respond. Whether or not it chooses to do so is a different question.
I think that's begging the question. I understand that they're always able to respond to a motion, but what she's trying to get at is once the state has a lawyer speaking for it, why shouldn't the defendant have a lawyer appointed? And that is a gap in Lujan, because Lujan talks about the judge determining on the motion, files, and records that it's without merit and summarily denying or dismissing.
It says that
And then the next step is you appoint an attorney for a preliminary hearing. And I understand this, there was no hearing here, I get that, so we're somewhere between those two options.
I don't know that we're necessarily between them. I think we're still squarely in the first, because the court may determine that the motion, files, and records of the case conclusively show the movement's entitled to no relief and summarily deny them that motion.
The motion, files, and records
of the
include
case
the
can
state's
include,
response.
Yes, can absolutely
Okay.
include the state's response.
Okay. Thank you.
You're welcome. I hope that does resolve that question, because I don't think that we're in any kind of uncharted territory here. Again, this is no different than an objection with a response, or even I would even point out that the Court of Appeals opinion in this case tracks fairly closely with my brief. That doesn't mean they delegated the authority to me to resolve this opinion. Sometimes we do have the right answer. Sometimes we don't. It just turns out in this case we definitely did. If I may, they weren't addressed from the podium today, but I did want to note just the specific claims. If this court has questions about any of the specific attorneys or the claims made, I would be glad to answer them. The bottom line is none of those claims were able to carry both prongs under Strickland. There's not even a suggestion that they could in reality. And I would also just note one procedural point that that I guess puts the state on a little bit on the back foot is that I'm aware that in this particular appeal, the defendant filed a 609 and attempted to put before this court or incorporate into the record in this case Mr. Sullivan's disciplinary case. The state responded. That motion has not been ruled on, but to the extent that it's before this court still appropriate to address today, we would stand on our response for the most part, but just reiterate that it is not appropriate. I think the Court of Appeals recognized that even the allegations that were a part of that case came years after the trial in this case. Moreover, the defendant at no point made any claim that any of the issues that came up in Mr. Sullivan's disciplinary case had anything to do with his trial. So, to the extent that this court may have questions on that issue, I would entertain them. I would ask that this court deny that 609 or reject it. And if there are no other,
I have a question over the $190.
Sure.
Doesn't Mr. Breedlove have a point that should be refunded to him? Wasn't that in error that was assessed to him?
This is a point that is. Quite frankly, I don't think I've ever seen before. I don't know that there's a lot of precedent for it. But the fact of the matter is twofold. Number one, that the Court of Appeals found, and I don't think that anything in the defendant's petition to this court changes the fact that he abandoned this argument. I don't know how he gets around that. The argument
By
was...
not challenging it in the district court. That's really a failure
Right.
to preserve rather
Yeah,
than
the failure to
abandonment.
preserve, yeah.
Okay, so if he hops the preservation hurdle, then what?
And then if he hops the preservation rule, I believe that under the law, as the Court of Appeals, and I set out in my brief as well, this fee is authorized under 60-2008, subsection A, for
I
any
don't
time...
think anyone's questioning the authorization for the fee. They're
Just
saying
what
he
it
had
says.
he filed a poverty affidavit when he first filed the 1507.
I didn't understand that to be the claim. My point, actually, the claim that I made in my brief was that he could have filed a poverty affidavit when he filed this dispositive thing, and he
Did he
failed
have
to do
to
so.
file a separate poverty affidavit for everything that had a fee attached to it? It doesn't go for the whole case when you file a poverty affidavit at the beginning?
I don't
thought
know,
that's how
and it may,
1507
but the point of the fact here is that 60-1507 doesn't actually provide for such a dispositive motion such as this. So he actually tried to proceed under a different statute and making an additional claim. So I think an additional poverty affidavit would have been appropriate. But number two, he paid it willingly, readily. I don't think he can validly make any claim of poverty for $195.
Well, he paid it after it was rejected in the first place because he didn't have it.
Right.
Initially he filed a poverty affidavit. I just don't understand why he was required to file it. Why he was required to file $195 to get his case heard when he initially filed the appropriate affidavit.
First thing I would say is he was not required to file that to get his case heard. I don't think that
How
there's
can you
anything
say
that
that?
suggests that.
When it sat for 2.5 years, no action was being taken, so he does something affirmative to do it.
That would require a
Well,
leap of inference to say that nothing was going on. We know that this was not the same district court that heard the trial. We know that the district court had this motion for some time. It then requested a response from the state. That took an additional amount of time, and then eventually it ruled 2 to 3 days after receiving the state's response. There's nothing about that fact scenario that implies nothing happened, that the district court was doing nothing here. And I don't think that the defendant can validly make a claim for relief based on pure speculation.
What in the world could the court have been doing?
I think the defense points out in their case that there were over 1,000 pages of transcript in this case. That's my point. I don't want to say what the district court was exactly was doing, but they have a massive caseload, and there was a lot of work that could have been going on here. I simply don't know. And the fact of the matter is, I don't think that it rises to any reason to question the result. If there are no other questions, the state would again ask.
So if he could have filed a action in mandamus would have been what he should have done, asking that the court do its job and set this for hearing.
Sure.
And that wouldn't have been a fee, right?
That's certainly a route that we could have taken.
And there wasn't, a motion for summary disposition was not a procedure that could have been filed. That was an incorrect labeling to start with. Would you agree with that?
I think that's a fair way to characterize it, because like I said, 1507 doesn't provide for summary disposition
Okay,
on a motion
so,
like that.
so when it was received, it was not appropriate anyway, and if we liberally construe a pro se pleading, why wasn't it construed as a mandamus action asking that this be set for hearing?
Yeah, just a motion to expedite.
Right, or a
Yeah.
motion to expedite, or whatever. What he was asking for is, hey, I filed it September 4th, and his first letter was in December, that was the letter from the clerk. August of 2015, not quite 2 years later, he's saying, what's happening? And why wasn't that construed as a motion to expedite or whatever?
I see the amount of time. I'm gonna try to answer your question. I'll be brief. But just because that there are multiple ways to construe a motion does not in any way mean that the district court's chosen construction was in error. And when the district court construed it as captioned by the defendant in this case and required the filing fee, there's nothing that was statutorily erroneous about that.
Well, where does it say that a motion for summary disposition is subject to a $195 fee?
60-2008 subsection A authorizes that.
But not in the district court. Not for
For a dispositive motion, I think.
Well,
that does.
but it's not a dispositive motion if it's not authorized. There is no such thing as summary disposition. That's an appellate motion.
Oh, there are motions for summary disposition in the district court. I think that the case immediately before me, granted, was a civil matter, but there was a summary motion in that case.
Summary judgment, yes.
Yeah. And so summary disposition is, again, I think that's something that can be heard at the district court as well.
This is the big $750,000 moneymaker.
I don't think that it is. It's
Well,
$195.
no, it didn't. No. I'm talking about the intention behind the statute
Oh, yeah.
to charge for dispositive motions. Never mind.
No, I got it. I track with
At
you.
$175 or $195 a pop was going to get $750K for the judicial branch. Okay.
So, with that, if there are no other questions, I would respectfully request this court, A, reject the 609 that was filed by opposing counsel, and B, uphold the ruling of the district court denying defendant relief on his 1507.
Do we have any more questions? Thank you, counsel.
Thank you all.
Counsel, I have a question. What is the triggering event here for when counsel should have been appointed for your client, as you suggest?
Well, 60-1507B is pretty clear, isn't it? Unless the motion and the files and the records of the case conclusively show that the prisoner is entitled to no relief, comma. And that's the first Lujan option. Then the court shall cause notice to be served upon the county attorney, grant a prompt hearing, and appoint counsel.
So when the judge looks at this and says, I cannot rule on what's before me, I'm going to give the state a chance to respond, once the judge makes that determination, counsel should be appointed.
I believe so. Yes, I think that's a strict ruling of Lujan, which is based on 1507B.
And I think opposing counsel said actually once the court has looked at the pleadings filed by the state, then you're still back in step one. So how do you address that?
I think, unless, like I said, unless it conclusively shows, because you know what the 1507 movements file. I mean, sometimes, they're way out of time, or they're arguing trial errors that would have had an abuse of discretion standard, that you can't really raise in a 1507. But there was more to that. Kind of go to what Justice Johnson was talking with opposing counsel about. One of the things that kind of bothers me about this is alibi. He raised an alibi claim. And there are events that basically only he and his trial attorney know about. They're not going to be in the record. So you don't know really whether he had a valid alibi claim unless you appoint counsel for him and get it set, at least for some sort of a preliminary hearing.
Counsel, can you refresh my recollection? Did the state just unilaterally file this response, or was it requested by the court?
It appears to have been requested by the court by email, which might have come more from the judge's administrative aide rather than from the Judge Fleetwood himself. A year and a half, I think, after Mr. Breedlove filed his motion. There's no, say, written order directing the state to file a response where there could have been. We would know that Judge Fleetwood really looked at it, and then appoint counsel for Mr. Breedlove in that case.
Actually, it was shortly after the move-ants motion for summary disposition. I think that was August 10th. Then Judge Fleetwood asked for a response, and then September 17th, the state response.
I thought there was maybe something in March of 2015 that it might be buried in the registry of actions. That's where I had to go for a lot of what really wasn't showing in a technical pleading. As far as Mr. Sullivan goes, I apologize if my 609B letter was inappropriate. I don't know that it was. I think to a certain extent, anything that is in this court's own files can be taken judicial notice of by this court, and then of course you can give it the weight and credit that you think it deserves. I also know now, I didn't know when I wrote the brief, but I know now that Judge Fleetwood would have gotten an order from this court suspending Mr. Sullivan's law license in March or April of 2014, I think it was 2014. Certainly well before he ruled.
I wanted to change the facts and the situation slightly and see if I can get your response.
Okay.
The motion is filed, and the state, just on its own, files a response.
And that
Is it-
happens a lot.
Is it your position that at that stage, the court is obligated to appoint counsel?
Perhaps not, but it also may depend on the motion that the movement has filed. First of all, certainly whether it's timely or not, the allegations made in it, and
Obviously, the court needs to consider the motion. I
Right.
mean, that's right in the statute, motion files and records. So, just so we're clear, you're arguing only the case before us today, where the record tells us, or at least we think the record tells us, that the judge requested a response to the motion by the state. Then the trigger has occurred, or has been pulled, I guess.
that's what I would argue.
Okay.
Yes.
And you're not necessarily arguing that it also extends to the hypothetical just described by the chief.
This in some ways kind of goes back, the constitutionality argument is kind of a little bit intermeshed with this. In Woodward, the unpublished opinion from this court in 2011, the response that the court adopted was only 6 paragraphs long. So it also might depend on how extensive the movement's motion is and how extensive the
I'm not
state's
talking
response
about the
is. Okay.
later adoption
Okay.
of the findings and conclusions. I'm talking about when we have to be concerned that the defendant or movement has counsel. And I'm just talking about that,
Right.
not about what the state has in its response.
If the state does do that, then I suppose just on its own, fairly quickly after the motion is filed, then I suppose it would have to be up to the district court judge.
Okay. Thank you.
Okay.
So the distinction is that the requirement is if the court, as it appears in this case, sent out 2 emails, one in March and one in June, requesting a response, that would trigger, in your mind, appointment of counsel.
Yes, I believe it is.
Required in
yeah.
any circumstance.
And I realize you don't want different rules applied for second or 22nd 1507s, but this was a first. That's important to me.
Counselor, you're out of time. I want you to, before you sit down, to address a couple of preservation arguments with regard to the findings, the court's adoption in toto of the state's response as its findings. There was no objection at the district court level, and I understand how you're going to do that if you have a summary denial. But the next step is when you appeal. I think we said you have to explain why it wasn't raised in the district court, and that didn't happen, did it?
Probably not. I really do try to follow that rule, even when I don't think that I have to. I also think in the 2.5 years almost since I wrote this brief, that the Court of Appeals at least has gotten more strict on the, well, you didn't object to the findings and fact and conclusions of law part of it.
Okay,
So-
with regard, the second item is with regard to the $195. Obviously, it was paid
Right.
rather than an objection filed or challenged, and we don't have any argument on appeal as to why we should consider that without the preservation, do we?
Yes.
Yes, we do, or yes, we don't.
I didn't.
That was a confusing.
Here's the way to answer your question, Justice Johnson. I'm aware of the rule and I didn't ignore it. So on page 27 of my brief, I said, Breedlove raises this issue for the first time on appeal. Counsel is unaware of any published case law requiring him, pro se and indigent, to first raise this issue before the district court. So if it is something that should have been raised and preserved by a pro se and indigent movant who's in prison, then that's an issue of first impression.
No, it's the problem that I have with it. I mean, you made a shot at it in your Court of Appeals brief, but the Court of Appeals specifically quoted that language from page 27 of your brief and said it wasn't good enough.
Okay?
And then when you filed a petition for review and you're supposed to tell us why the Court of Appeals erred, you didn't do that. You just said, oh, I put on page 27 this language that they quoted and said wasn't good enough. So what you never did was argue why it wasn't good enough. You know, why they were wrong.
Well, they were
why
wrong.
it was good enough.
Certainly most of the time under, is it 602A5? You're certainly substantial rights is one of the ways that you can get to consideration of an issue, even though it was not raised in the district court. And I think then you've got the problem of the chilling effect that it potentially has.
That answer doesn't make sense in the context of the petition for review. You know, the Court of Appeals said, this is what you said in your brief, that's not good enough, you're supposed to cite one of the exceptions, and all you did was say, look at page 27 of my brief. And I'm trying to say, where did you tell me why the Court of Appeals was wrong in what it did in your petition for review?
I suppose with my 15-page limit, I was mostly focusing on the other issues, and so I apologize. I probably did not address that as well as I could have or should have. If that's the best answer that I can give. So,
Do you have any further questions? Thank you, counsel.
thank you.
Thank you both for your arguments this morning and this afternoon. The court will take this matter under advisement. That concludes this morning's docket. Court is now in recess until 9 o'clock tomorrow morning.